Today we're discussing what happens when you get into an accident without insurance coverage. Okay, first, this video does not create an attorney-client privilege or an attorney-client relationship. You watching this video doesn't make that happen. Feel free to check out our contact information in the link below or on www.adrianlawfirm.com. I'd love to work with you. Hit us up for a free consultation on whatever your issues you're facing, and let's see if we can work together. Second, this information is just for informational purposes only. It does not constitute legal advice. Do not apply it to your specific situation of facts and law. If you find yourself in any of the situations that we might be discussing, reach out to us via that contact information and we'll see if we can see what law applies to you in your specific circumstances. All right, so before we discuss what happens if you're in an accident without insurance, let's discuss generally what is the usual course of things. What happens when you are in an accident with insurance, like a regular accident should be. When you are in an accident and you've suffered because someone else was negligent, either they were violating the law by following too close and rear-ended you, or became distracted and didn't see you and then hit you. They were just not paying attention, they made a left turn in front of you and they don't use a blinker and they merged into you, or coming up on them, they didn't use that blinker and then they merged into you. Whether you were the victim of someone's negligence or recklessness, you usually suffer in some way. You are entitled to a measure of how much you've been hurt, a measure of damages, okay? Damages include your property damage, right? Like your vehicle. If there was something in your vehicle that got damaged, like a computer or a laptop or a child seat, right? So that's property damage. And obviously also medical bills, right? When you get hurt because of someone else's negligence, that someone else owes you the cost of medical treatment that was made necessary because of the injuries in the accident, right? The final category is pain and suffering. What's generally known as and referred to as pain and suffering, that is covered in California Jury Instruction 3905A. Mental pain, physical suffering, loss of enjoyment of life, inconvenience, grief, anxiety is essentially what sets you apart from just a regular object, right? So if someone comes around and breaks my water bottle with a baseball bat, I'm entitled to replace this water bottle, right? But if someone comes around and hits me with a baseball bat and causes me to, let's say, suffer a broken arm, I should be entitled to more than just the cost to repair my broken arm, right? I have suffered as a human being. Whereas we don't allow suffering for inanimate objects, the law takes into account there are damages to the person. So that's what happens when there's a regular accident. Are there any special rules that apply when there's an accident that happens and the person, the victim of the negligence or recklessness, was not insured? And the answer is yes, there are specific rules for those cases when the victim of the negligence and recklessness does not have insurance. Let's take a look. We'll try and put the law up. It's a little long. California Civil Code section 3333.4. So it was Proposition 213 back then. The bulk of the code reads as follows. In any action to recover damages arising out of the use of a motor vehicle or the operation of a motor vehicle, a person shall not recover non-economic losses to compensate for pain, suffering, inconvenience, physical impairment, disfigurement, and other non-pecuniary damages if any of the following applies. Okay, so section 1, the injured person was at the time of the accident operating the vehicle in violation of the following codes or under the influence of alcohol or drugs. You will be barred from getting pain and suffering, even if the accident is not your fault. So you might be able to get property damage, you might be able to get some medical bills paid for, but you're not going to be compensated for the loss of your time, effort, pain, inconvenience, grief, anxiety, all those human factors, because you were driving drunk. So don't drive drunk or under the influence of drugs. Section 2 states, the injured person was the owner of a vehicle involved in the accident and the vehicle was not insured as required by the financial responsibility laws of the state. So if I own a vehicle and I'm riding shotgun and my friend and I are just driving along and someone hits us and it's the other person's fault, even though I am just a passenger, I was the person who knew that our vehicle should not have been on the road because we did not have insurance. I am barred from recovery. There are some nuances to this, so if you have a specific question, you're in this specific issue, give us a shout out. We'll find the law that applies specifically to you. In the third section, The injured person was the operator of a vehicle involved in the accident, and the operator cannot establish his or her financial responsibility as required by the financial responsibility laws of this state. The driver of a vehicle that is uninsured is barred from recovery of the human factor losses. But there is an exception. If the person that caused the crash was under the influence of drugs or alcohol, the state says, no, there's some fairness here, right? So both of you guys were in the wrong. In the event that a person described in paragraph 2, so like an uninsured person, was injured by a motorist who at the time of the accident was operating his or her vehicle in violation of section 23152 or 23153 and was convicted of that offense, the injured person shall not be barred from recovering non-economic damages for pain, suffering, inconvenience, and the rest of it. In an accident, you typically can get compensation for property damage, medical bills, past and future, loss of income, provable loss of income, it can't be speculative, and human factor type stuff, pain, suffering, inconvenience, loss of enjoyment of life, grief, anxiety, humiliation, it's stuff that makes us human. All of those go away, so you can only get medical bills, property damage, if you were not carrying insurance at the time of your accident. So do not drive around without insurance, because it makes your case go from what could potentially be a huge value to almost nothing. Oh, you're also barred from all of those items if you were the one drinking and driving, even if you did not cause the accident. I know it's expensive, but you know what's more expensive than driving with expensive insurance is driving without insurance and then getting caught for it, right? Or getting into an accident where you should be getting taken care of and you're not because you were barred by Proposition 213. If you have any questions about what insurance coverage you should get, we should be putting on a new video on that specific subject so that you can protect yourself from those people still driving around without insurance, because that unfortunately is still a thing in California. You don't want to be left in the dust if you just had, the bare minimum policy. Someone causes a crash and they didn't have any insurance. Thanks for tuning in. If you like this video, please subscribe. It'll help us put out more videos. So we want to be as educational as possible, but it has to make financial sense for us. So the more subscribers that we get, the more videos that we can push out. If you drop a like, it'll help other people find this video also. And if you have any questions, drop it in the comment section below. See if we can get to those topics soon. All right, take care, guys.